Hi, I'm Tom Johnson, Vice President of Public and Board Relations at Chicago BBB. I really want to thank everyone for attending today's webinar. It's the mission of the BBB to promote great expertise and marketplace trust. And one of the great services that we can provide is bringing you leading experts on topics that you want to hear about. It's our pleasure today to provide you some of this assistance on sexual harassment training from SmithAmundsen. And please welcome Carlos Arevalo, a partner at SmithAmundsen, who will be leading today's panel. Carlos, welcome, and thank you for doing this.
Good morning, Tom. Good morning, everybody. It's my pleasure, to be working with BBB today and to bring this resource of the sexual harassment training that we're all supposed to do. As Tom said, I'm a partner at SmithAmundsen with the Labor and Employment Practice Group, we'll go through the training. Hopefully you get what it's intended to give you. And again, it's my pleasure to do so. As we begin today, I guess the first question you'd ask yourself is, why are we doing this? And really, it comes down to the fact that the state has now made it a requirement of all employers to go through the process and to provide their employees with their training. With the training on an annual basis. So, this is the first of many to go annual. And I know that we're going to get the slides working. I believe that that's something that's coming so that we can start. To the extent that you may have questions, I think that the way that that'll work, it'll be to, kind of wait towards the end of it to make sure that we're all prepared. Let's see here. Let's also discuss the something that I need to bring up, which is a disclaimer, and you will see that in the slideshow as well. The information that I'm giving you today is general in nature. It doesn't necessarily apply or is specific to any one employer. One of the things that we will say to you and that you should keep in mind is that your employer should have its own set of policies that address these particular issues with respect to sexual harassment, the equal employment provisions, and all of those sections of the policy that kind of govern how your business, your specific company would deal with these particular issues. And so that's something that's obviously unique to your company. Today's session is really meant to be a general session so that you can, kind of get the gist of what we're doing today. And to that end, obviously, if there's any specific question, anything, dealing with your specific situation in your specific place of employment, our recommendation to you would be to go to your human resources professionals or a designated individual at your company to talk with them about, and also, and if it's appropriate, obviously, for those of you who are human resource professionals, that perhaps you may need to speak with somebody at your place of business, and potentially even go to your attorney. So that's how this works. It's generally general information. You still have your own responsibility to, comply with all the legal obligations. So now I see that the slide is up. And so let's talk about, what employers are doing. What the state has done is it's really require employers to adapt and implement policies and practices. And the whole point of that is to make sure that your employees, if there's any issue before them, any issue dealing with harassment or discrimination, and we're talking, while this is really intended for sexual harassment, we're talking about any kind of discrimination, any kind of harassment that takes place. It's not necessarily limited to sexual harassment. So those policies that are being adapted and implemented, are for the purposes of employees being able to go to management, bring these issues up without having to worry about any kind of, retaliation or any kind of potential loss. So the other thing, obviously, is that the goals of the companies, the employers, is to make sure that all decisions are being made, decisions that impact individuals and their terms and conditions of employment, that they are being made for the proper, proper reasons, business legitimate reasons, not on any unlawful basis, which again, that would be gender, that would be race, sexual orientation, whatever protected classifications we're talking about. So let's go on to what we'll discuss today. First, we'll talk about sexual harassment under the law. You get to go through that process. We'll also discuss, what kind of conduct constitutes unlawful sexual harassment. We'll give you some examples. Some of them, of course, are common sense that, we all kind of understand would be, examples of conduct that we should not engage in, but you'd be surprised. So that's why we kind of list them and go through them. We'll also go through a summary of the federal and state statutory provisions that specifically address sexual harassment. And we'll talk, a little bit about the remedies that are available to individuals who make those kinds of claims. And finally, we'll go through the responsibilities that employers have with respect to the prevention, the investigation, and the, what corrective measures need to be utilized and employed with respect to sexual harassment. Now, as I mentioned earlier, this is based on statutory provisions. Sexual harassment is prohibited under the law. Common sense, we all know that. That's been the case for a while. The Human Rights Act in Illinois makes it a civil rights violation for anyone, any employer, any employee, any agent or employment agency, union, labor organization to engage in sexual harassment. And so because the Assembly has determined that, tolerance of sexual harassment has a detrimental, influence in the workplace, we have these requirements. And the thing about it is that sexual harassment has a tendency or can create a hostile environment for employees. It affects their productivity on the job. And of course, there's legal liability that comes out of it. So we have the policies that we've discussed that hopefully your employers have in place. And if not, they should be having those policies in place so that employees can, again, bring these issues up without having to worry about any retaliation, any fear for their job, any kind of loss of a promotional opportunity or other job opportunities that may exist within the company. So let's look at other things that we'll discuss today. We're going to talk a little bit about diversity. As I said before, this is not really simply limited to sexual harassment, but there's also other, the diversity that we're dealing with is not just about gender and sex. There's other kinds of, things that make us diverse. And so we're going to be talking about that. The people that we interact with on the job, they're all very unique. They have their unique backgrounds, views, personalities. So we're going to discuss that. We're going to go through some legal definitions so that we are clear as to what unlawful harassment and discrimination is and how we can prevent it. As I said before, we'll give you some examples of the conduct that constitutes unlawful sexual harassment. We'll look at risky workplace behavior to make sure that we kind of avoid those sorts of things. And then finally, we'll go through the responsibilities of those involved with respect to what we need to be doing so we can prevent it. If there's the need to report it, we could do that. And what else? Okay. As I said at the top of the hour, employers now are required to provide sexual harassment for all employees, right? So it doesn't matter if we're talking about short term. It doesn't matter if we're talking about part-time. It doesn't matter if we're talking about interns. Everyone has to be trained on an annual basis. Independent contractors on site with an employer, employers' workers should also acknowledge that they've gone through their own, harassment training for their employer, for whoever it is that they're work with. So, it's not going to be limited to the employees, particularly for those businesses that are in work sites or facilities where there's more than one employer around just by nature of the business, the work that they do. All right. So however we look at it, all of us work in a very diverse place, right? There's going to be diversity. And so what becomes important is for all of us to understand and respect the individual differences that each person in that place brings. We need to keep an open mind towards others who are different from us, and have to remember that not everybody sees things the same way that you do. So we're all unique in that sense. And we're not just talking again about skin color, gender, gender identity, sexual orientation, your religion, ethnic background, those things that are protected classification. Diversity is much more than that. It brings personality, thinking style, your values, your habits, what kind of background we have with respect to education, with respect to training we may have, the kinds of ambitions we have, the kind of people that we are. We all have political views and lifestyle, differences that we need to take into account. That's all part of the diversity. Same thing with where we work, the kind of job that we do, and personally, how our sense of humor, how sensitive we are, the kind of person that we are, which also then brings our, family type background, where we grew up, the kind of families that we belong to, the kind of families that we have, back when we were growing up, in the present time, those types of things. And again, we're all different. So all of these things is what makes, it's diversity. This is what diversity is all about. And they change over time. So again, what becomes key here is that we all have the right to courtesy and respect in the workplace. We need to remember that we all have a responsibility to fight prejudice and discrimination in the workplace so that we don't have these kinds of issues. We need to be able to be listening and observing, how others want to be treated so that we can kind of treat them accordingly. And that will promote a culture of inclusion. And the one thing that's also important too is that, as I mentioned before, these things change. Our views change. Our political leanings might change. Whatever. These are all things that are subject to evolution, our thought, or our inclinations. And so what happens with that is that something that might have been acceptable or that you might have found acceptable back 10 years ago, all of a sudden it's not so acceptable today. And so because of, and obviously we're not just talking 10 years ago, we're talking as things developed. So crossing the line can happen fairly quickly, fairly easily. So we have to, keep those things in mind. All right. So generally speaking, unlawful discrimination means when there's actions that are taken that adversely affect an individual because of that individual's real or perceived. It doesn't have to be actually, the classification. It can just be something that you think it is, perceived. Race, color, religion, national origin, ancestry, age, sex, gender identity, marital status, if there's an order of protection in place, if there's an arrest record, other things. And we have a full list here, that is part of what the law provides are protected classifications, right? So anything that the law deems to be a protected classification, you cannot make any kind of adverse job decision based on those things. So that's what unlawful discrimination generally means. Now, harassment is when there's any kind of unwelcome conduct that is based, again, on that individual's actual or perceived protected classification that has the purpose or effect of substantially interfering with the individual's job performance or work performance, or that creates an intimidating, hostile, or offensive work environment. Now, as I said before, the work environment is not limited to the facility where you work, where the business is set. It goes, beyond that. It's beyond that physical location, particularly with entities that, travel or that do jobs on site that are not necessarily a facility. So it's not limited in that sense. So work environment is really where we all do the work, which could be in-house or it could be somewhere else. All right, so that was harassment. So now we're talking about sexual harassment specifically. And that is any kind of unwelcome sexual advance or request for a sexual favor or any conduct of a sexual nature when one, submission to such conduct is made either explicitly or implicitly a term or condition of the individual's employment. 2, submission to or rejection of such conduct by the individual is used as the basis for employment decisions affecting that individual. Or, meaning that any one of these three, doesn't have to be all three, can be any one of these, such conduct has the purpose or effect of substantially interfering with an individual's work performance or that creates an intimidating, hostile, or offensive work environment. Again, we talked about how working environment is not limited to the physical location where we do our job. Now, there's a standard. How do you determine the hostile work environment? Now, this is the victim, the individual who's subject of the harassment, has to be subjectively and objectively offended. An individual is going to be subjectively offended is just based on how they see it, how they perceive it in their mind. So it's their own opinion. How, am I offended, individually? Now, you also have to take into account the reasonable person standard for what is objectively offensive. So if you were to take 10 people, and then you have, the majority of them, a good number of them, who find something objective, that's going to, kind of give you some sense of what reasonable objective standard would be with respect to something that's offensive. But we have to look at it in a similar environment under similar or like circumstances. So that's what creates an objectively offensive situation. Now, simplified, right? If there are employment actions that are adversely affecting an individual because of their real or perceived protected characteristic, then that's what's going to bring harassment into the picture, or discrimination. So, I'll give you an example here. When you terminate the employment relationship with an individual, let's pick a female employee, and you terminate her simply because she is a woman, that would certainly be illegal. You're taking adverse action because of her gender. Now, if we take the same person and she's legitimately a poor performer, somebody who's not doing the job, somebody who's not fulfilling the expectations of the job, in such a way that perhaps you need to take some disciplinary action, then that would be legal. But as we often talk with clients, that's not something that can simply just be developed with nothing in the background. There's no documentation. We have to know that that's going on, and as employers, the employers have the responsibility to make sure that they're looking at this and developing the situation and keeping an eye on it to make sure that those legitimate reasons for taking any kind of adverse action are going to be there to support it. And the same thing, applies across the board. Now, what is an adverse employment action? That's if, discharge. Obviously, termination would be one. We made reference to that. But there's also other things. Failure to promote, any kind of demotion that take place, any kind of material negative change in benefits for an individual, or if there's an adverse compensation decision. It could also be changing an individual's job responsibilities, when they're negative. It may have an impact on the kind of earnings that they have, as a potential instance of it. So, the other thing, of course, is that it's not just those kinds of specific tangible actions, but it's also the kind of action that takes place that creates that environment where one is unable to perform their job because the harassment is substantially interfering with the person's ability to do so. So again, as I noted before, if there's a legitimate business reason for whatever action is being taken, that's going to be appropriate and is generally going to be lawful. But things have to be taken into account to do this. So let's talk specifically about sexual harassment. There's two types. And the first one is what's called quid pro quo. And that occurs when an individual's submission to or the rejection of sexual advances or conduct of a sexual nature is used as the basis for an employment decision that affects that individual, or where if there's a rejection of that conduct, and obviously it's made a term or condition of their employment. An example here: a boss is demanding sex from a subordinate. If you do this for me, I'll make sure you get that promotion. That's going to be, that's kind of like the basic example of quid pro quo. Common sense, right? But, it does happen, and sometimes it's unclear to people. This instance or this situation is very unique to sexual harassment when you're doing this type of thing. The other form of sexual harassment is what's called hostile work environment. And I'm sure that many of us are very familiar with this term. We've heard it before. And that occurs when unwelcome, unwanted sexual conduct unreasonably interferes with the individual's job performance or creates a hostile, intimidating, or offensive work environment, even though that harassment doesn't necessarily result in a person, losing pay or having any tangible job consequence. Now, employers, supervisors, co-workers, customers, clients, vendors, all these individuals can create a hostile work environment. Now, the one thing about a hostile work environment, again, we've talked about the fact that while the emphasis here in the training is for sexual harassment, that can occur, a hostile work environment can occur and be based on any other protected classifications that we've discussed before. So it could be related to race, it could be related to religion, ethnic origin, or national origin. So all those things can form a hostile work environment. All right, so some examples. The repeated request for sexual favors, or if somebody's pressuring somebody to go out on a date. There might be the kinds of things where there's some demeaning sexual inquiries or vulgarities. It could be the language that we use. If it's offensive of a sexual nature, that can be the basis of it, can form a hostile work environment. Other verbal or physical conduct of a sexually degrading nature. It can be images and things that are sexually offensive, that are in plain view. If you have your workstation and there's, posters or calendars, back in the day, any mechanic shop might have had some kind of fancy calendar, right? Where the emphasis wasn't really on the vehicles or the tools. It was on something else. Certainly that could be offensive. And now, obviously, with everyone having smartphones, there certainly is an ability to have something very readily available and in plain view. It could also be any kind of sexually offensive or vulgar communication, and that's obviously face-to-face communication, statements that you say to somebody, to their face, to their person, but it's also other communications that might be through emails or text or other media that we'll discuss a little bit. And again, this is not limited to just sexual work environment and harassment related to that. It could be on any other protected classification. Some additional examples, just to make it even more clear. Somebody touching somebody, deliberately doing so. If you lean over a person, leaning over somebody's workstation. Or cornering a person in the hallway. It could be the kind of sexual looks or gestures, whistling at somebody. It could be sexual teasing, jokes, remarks, or types of questions of that nature. It could be name calling or uses of names that are not acceptable for the workplace, or they're not appropriate. There's some examples there. It could be actual or attempted, sexual assault or battery. One of the less clear things is, having a discussion that's all work related, but then somebody turns it around and it becomes an issue of now it's a sexual topic that everybody's discussing. And then of course that leads into, discussing sexual fantasies or preferences or somebody's history, and the comments go on and on. It could be then also discussions or comments about the way a person looks, the way a person's dressed. Generally what their body looks like. It could be other things. It could be telling lies or spreading rumors about a person's sex life. It doesn't have to. It can just be a story that's made up, but still of a sexually degrading nature that would not be appropriate. Again, we talked about the touching part. The individuals that get comfortable and either massage somebody's neck or their shoulders. You're touching them or their clothing or their hair or their body. So all of those kinds of things obviously are sexual harassment. There are some things, of course, that are not unlawful, and that's if they're welcome or wanted. So folks can go on lunch or dinner dates if they want to. You can exchange appropriate compliments, or note somebody, if they have a new hairdo or if they have a nice dress, you look very nice today. That would be appropriate. You can also be courteous in any kind of act of courtesy, or any kind of exchange of a common pleasantry that might be what people do when they see each other, when they greet each other. The thing to point out is that work is really for work purposes. It's not where you go to pick up dates or to find your soulmate or the love of your life kind of thing. It's work is for work purposes. Let's talk a little bit more about unwelcome behavior. Now, behavior may be unwelcome in the sense that the person, the victim, is not soliciting it or inviting it. Sometimes what's welcome behavior can quickly become unwelcome. So it might be, a joke or something that's, said or whatever, and the person certainly has, kind of said, okay, that, no big deal. But of course, there are instances where, a line is crossed, right? And something that was okay and acceptable before, all of a sudden is not, and it becomes unwelcome behavior. We also need to keep in mind that consent can be revoked. So if somebody all of a sudden is in the middle of a discussion where things begin to take the wrong turn and they, start going or crossing the line, whatever, all of a sudden they find themselves in an unlawful harassment type of situation, that person has the ability to say, you need to stop talking like this, or you need to leave me alone. And that has to stop then. If the person does make that request, he has to stop. The person who engages in this type of behavior is not going to be able to say, refer back to earlier behavior and simply say, oh, well, you started it, or you were okay with it at first. That's not going to be valid. That's not going to be an excuse. So who can be harassed? A man or a woman. It can be, doesn't have to be of a different person, doesn't have to be of a different race or national origin or gender, doesn't have to be of a different sexual orientation or identity. It can be, any of these individuals. It can be a non-employee. We're not limiting ourselves to people that we are peers or work with. It can also be an indirect person, a party. So not necessarily the target of the behavior, by somebody who witnesses it and may overhear it or see it happen. They can also be harassed. Bottom line, anyone can be harassed. Now, what about the harasser? A harasser can be a direct supervisor or manager. It can be any supervisor or manager that has influence, obviously, because of their position. It could be subordinates harassing a supervisor. It happens, right? Traditionally, that's not the case, but it does happen. It could be the coworkers, your peers, right? But as I said before, it can also involve non-employees. So vendors, suppliers, customers, other contractors, folks that might be in the place that we work that are not necessarily working with our company. If there's going to be interaction, if there's an expected, work that we might be doing together, they are going to be foreseeable, and therefore they're going to be harassers. So anyone, right? And non-employees, let's develop that a little more. Again, we talked about the fact that the workplace, or the working environment, I should say, is not limited to the physical location of where the work is done, but it might take us elsewhere. Like at different points in times, we might have to travel to a different site, moving work or site location. So because of that, we're going to come into contact with people who are not necessarily employees of our company. So that prohibition, the supervisors and coworkers not engaged in harassment, applies to those individuals as well. So the customers, the other contractors, other suppliers, other service providers, they're going to be just as subject to the issues as we are as employees. They can be victims, but they can also be the perpetrators. So it goes both ways. Social media, right? Again, we talked about the fact that we're not limited to where we are. And that's for location purposes. But then we're also dealing with social media and online activity. And that is never limited in the sense that we can access it at any time. So the conduct or behavior that that happens and it potentially constitutes harassment, that could happen even when we're not at work, we're off the clock. We could be out of state, we can be somewhere else. And so it doesn't really, there's no limitation in that respect. Online harassment includes those emails, those cell phone texts, internet postings, online comments, blogs, or social media, whatever platform may be at issue, Facebook, Twitter, LinkedIn, Instagram, YouTube, you name it, Snapchat, TikTok, all of those, any kind of communication that occurs through those media certainly is, if it's of sexual nature, can constitute sexual harassment. Examples are when somebody's flirting or requesting or demanding to go on a date, or worse, to have sex, right? It could be sending inappropriate pictures or videos that include sexually graphic material. It could be the language, again, that we use in our communication, in our messages. It could be cyber stalking. All right, the point here, and what's very critical, and something I always tell folks when I do this type of training, that is something that you need to take with you, right, is intent versus impact. Regardless of the intent, the behavior is going to be judged on its impact. So, I didn't mean anything by it. Oh, I was just joking. That's not going to be a valid defense. That's just not going to cut it. The law is going to focus or look at the impact that somebody's action, somebody's behavior, somebody's conduct has on the other person. That's what's going to be critical. That's what you have to keep in mind. So what can we do then if we experience ourselves, or if we witness, or we become aware of unwelcome sexual conduct or any other offensive conduct? Again, we made reference to it before. You have the right to tell the person to stop, and it has to stop. The alternative, of course, is that you have the right to report that conduct, that sexual harassment. And several options are available. And we begin obviously with your human resources professionals or office manager, whoever supervisor might be. But let's look at that specifically, what the other options are that we have. And we begin with, again, we can report it to the employer, which is what we've mentioned. And again, these kinds of things are fairly personal. The person who is going through this kind of behavior or experiencing this kind of conduct, can make the choice to do any of these things, use any of these reporting options, and they can use more than one if they need to. But again, you report the incident to your employer. You can also call the state of Illinois Sexual Harassment and Discrimination Helpline. You can file a charge with the Illinois Department of Human Rights, or you can file a charge with the United States Equal Employment Opportunity Commission. So let's look at these options. Ideally, employers are going to have policies, right? And these policies have to provide provisions or encourage internal reporting. Right? So you can go to your supervisor and you report it, any member of management, somebody that you trust. These individuals have to have a sense of and understand what the process is, the internal complaint investigation and resolution process is, and they can certainly take action to ensure that there's positive change right away, and that the situation, the condition can stop. You can also go to your human resources personnel or professional if that's a position that's available at your place of employment. They'll work with management, they'll work with the supervisor, the folks at the HR department, to go through the process and take action, whatever may be necessary. Some instances that may be the preferred option because of the fact that the person involved in the harassment might be a supervisor, or might be a manager. In some other places, there might be a specifically designated reporting officer or manager that you go to make these kinds of reports. They specifically receive the investigation, the complaint, then they carry on an investigation and do what's necessary for that purpose. Now, the law doesn't require employees that they have to go to their employer first, or and report the complaint or the conduct or the behavior. But it's often the most effective and efficient way of actually resolving an issue at work, because that first of all, that something will happen, and then you also have the ability to take prompt remedial action, much more effective, much more immediate than if you were to take the other options that we have. So let's look at the second option, and that's the one where you call the helpline. Okay, if somebody's experiencing that any kind of behavior of this nature at work, they can certainly call the helpline. There's a number to call. There's also the website. The individuals that are there can answer questions. They can help you deal with issues, and talk about any kind of counseling or legal assistance that might be necessary. These are confidential calls. It can be anonymous, but certainly you can go through this option to report the situation or do something about it. Now, the next option is also with the Department of Illinois Human Rights, and that is when you file a charge. Now, the Department of Human Rights is the state agency that's responsible for enforcing the Illinois Human Rights Act. They will individuals that have a complaint, they can file a charge at any time within 300 days of the incident. The Department of Human Rights is going to have jurisdiction authority to investigate employers who have one or more employees. Now, the contact information, I think that's what we're dealing with the next slide. That's, there's a 800 number that you can call. There's also the website. The Department of Human Rights has offices in Chicago and Springfield and Merriam. There are the phone numbers there and the addresses and how you can contact them for those purposes. Now, what happens? What are the remedies available under the Illinois Human Rights Act? Okay, so the department is going to take that charge and they're going to do an investigation. When they complete that investigation, the employee making the complaint has some options. They can file a lawsuit in civil court, or they can file a complaint with the Illinois Human Rights Commission if the department has found that there's substantial evidence of a violation. Now, individuals who go through that process and ultimately prevail in front of the commission or a court, state court, they can receive an order that awards remedies that are allowed by the Illinois Human Rights Act. And the whole purpose of these remedies is to make that individual whole. The remedies can include back pay, any lost benefits. If there's an issue with the personnel file that needs to be cleaned up, it can also include that. It can be any type of other damages that have taken place. It could include reinstatement and front pay where reinstatement is not possible. And they also include attorney's fees and costs. Now, anyone who's making these kinds of claims and pursuing any kind of damages, they have an affirmative duty to prove that damages have occurred. And they also have an obligation to mitigate their losses and damages. And so now the last option, or the last reporting option that we have, is going and filing a charge with the EEOC. And that's the United States Equal Employment Opportunity Commission. This agency is responsible for enforcing Title VII of the Civil Rights Act of 1964. That's the federal law that makes it illegal to engage in sexual harassment or retaliation or any kind of discrimination. Individuals that, similarly at the state level, with the Department of Human Rights, have 300 days to file a charge, 300 days from the incident. Now, the EEOC has jurisdiction to investigate employers that have 15 or more employees. Now, the contact information for the EEOC, they have a number you can call. There's a number for hearing impaired as well. There's also the website. The EEOC has offices in Chicago and St. Louis that both serve employees in Illinois. And similar to the state, the remedies that are available I can show you in the next slide are similar in some respects. The EEOC does the investigation when they take the charge. Once they complete that investigation, a complainant, the employee, may file a lawsuit in federal court. The EEOC might engage with the parties to try to reach a settlement through what's called conciliation. That's an informal process, assuming that they have found that there's reasonable cause to believe discrimination occurred. Complainants who prevail in federal court may receive an order that awards remedies allowed by Title VII. And those remedies are similar at the state level, intended to make the employee whole. So they include back pay, they include lost benefits, they clean up a personnel file, any other damages or issues, reinstatement, front pay where reinstatement is not possible. They can also include punitive damages and attorney's fees and costs. Now, again, just like at the state level, the individuals, victims that have an affirmative duty to prove those damages, as well as a duty to mitigate any losses or damages they suffer. And in federal court, the compensatory and punitive damages are also subject to caps and limits that are imposed, depending on the size of employer. All right, so how are employers responsible for sexual harassment under Illinois law? Two ways primarily. If it involves a manager or a supervisor, and those are the ones engaged in the harassment, the employer is going to be strictly liable for the sexual harassment that's been perpetrated by these individuals, regardless of whether or not the employer knew that the harassment was taking place. Now, it could also include a coworker or non-employee harassment. In that scenario, employers are going to be liable for sexual harassment that's been perpetrated by these individuals, only if the employer knew or reasonably should have known of the harassment and then failed to take prompt corrective action. So the responsibilities that employers have to deal with these issues, they're primarily to prevent sexual harassment, to investigate any incident of sexual harassment or whatever discrimination, as we talked about, and to correct that incident of sexual harassment or whatever discrimination we're dealing with in the workplace. Let's look at these a little bit more specifically. Now, prevention, right? Employers have to develop, they have to implement, they have to communicate what the policies are with respect to sexual harassment and whatever discrimination. They have to make that available to their employees. They also have to provide training on harassment prevention, which is kind of this process that we're going through. Employers should be doing this, and as I said before, they have to do it annually now. They have to ensure that there's clear communication as to how to report any kind of incident, any kind of harassment, or sexual harassment, or other type or any kind of discrimination. The managers and the supervisors have to be alert. They have to know what's going on in their what kind of behavior is taking place, under their supervision, and they have to be aware of it. They also have to lead by example. Managers and supervisors have to, abstain from engaging in the behavior that the policy, and that the statutes, are against. Whatever it is, it's not the type of behavior they should be engaging with. Again, common sense, but it does happen. And of course, they also have to, if they see it, they have to take action. They have to do it in actual real time. They have to know what's going on. Again, as I said, what's the behavior, what's the conduct that is taking place, under the supervision. They have to be aware of it and to make sure they address it, to confront any kind of behavior that shouldn't be taking place. Now, of course, despite all the prevention efforts, it might be that, there's got to be an investigation because an actual instance or incident does take place, which brings us to employer responsibility having to do with investigation. And I believe that's in the next slide. There you go. All right, so if there's an issue, then the employer's responsibility is to immediately respond to a complaint of sexual harassment or any other kind of harassment or discrimination, if they have to initiate an investigation, okay? The first step generally is to interview that complainant, the victim, and they have to take reasonable action to protect that person while that is being done. Obviously, if there's an issue, the person might come to a supervisor, or might come to manager or human resources. They will indicate this is what's going on, this is type of thing. In some situations, and there's no writing that's required, but certainly that's a good thing to do, to write it down, to make sure that there's an understanding of what the complaint is, what is going on, to make sure that all of the issues that are taking place are being addressed. Certainly, there will be the names of some people who are aware or familiar with the situation, individuals who are witnesses who may have seen it. Those individuals need to be interviewed, just as the complainant, the employee will have to be interviewed to get all that information down. Anyone who has knowledge of it obviously is interviewed, and then the alleged perpetrator of the harassment also needs to be interviewed. And once that whole process is done, then this is going to be documented in some fashion. There's going to be a report of investigation that becomes an employer record that has to be maintained for purposes of keeping track of these things. And depending on what happens, obviously there might have to be some corrective action, which then brings us to the last point here of employer's responsibility, which is those corrective measures. Now, an employer has to take appropriate corrective disciplinary action, and in some instances that may include termination, where the policy has been violated, where there's obviously something that's happened. And there may be some situations where the conduct in question doesn't rise to the level of unlawful sexual harassment or a policy violation or whatever discrimination, but it's still nonetheless somewhat problematic or somewhat of an issue, and it's concerning. In that situation, an employer can consider some other alternative of corrective measure, which might be some additional counseling. It might be some specific targeted training for the individual so that he or she can understand what we're dealing with and how that is inappropriate behavior. It could also mean closer supervision of that individual to make sure that you're keeping an eye on him or her. It also means that maybe some reasonable action has to be taken across the board within the organization to make sure that the type of behavior doesn't happen again. So perhaps the employers may have to update the policies or do something that's uniquely tailored to the situation. Supplement or tailored training. Or there may be some instances, depending, obviously, in some circumstances, it may not be feasible, where you have to restructure the working environment or the reporting relationships in the hierarchy. So those are things that can be done to take some action. The employers also have to follow up with that individual who brought up the complaint and stay in touch. Make sure that the individual understands that steps have been taken to make sure that this is not going to happen again. To make sure that person is not the subject of additional harassment or retaliation as a result of having, filed a complaint and gone through that whole process. Bottom line, the employer's responsibility is to ensure that the complaining behavior or the conduct doesn't happen again or doesn't continue moving forward. So what's the key then to avoid the harassing or discriminatory conduct? We need to, again, be aware of how our behavior affects the people that we work with. And so again, this takes that listening and observing part, how other people want to be treated. And so then, that's how we understand this. And if our behavior or our conduct is something that makes someone uncomfortable, then we shouldn't do it. If it's something that we say that doesn't have doesn't make somebody comfortable hearing it, then we shouldn't say it either. So don't do it, don't say it. The rule of thumb here: if you're not gonna say it or do it in front of your spouse, significant other, family member, your mother, right? If you don't feel comfortable saying it in front of those folks, then we shouldn't say it or do it in front of anybody at work. All right, so retaliation concerns. That's something that's obviously part of this whole process. Companies, employers are not to punish an employee because they discriminate against a person or discriminate against that person because that person engages in what's called protected activity. What's protected activity? That's filing a complaint, accusing somebody that they're engaged in sexual harassment or race discrimination. It could also include when a coworker is supportive of another coworker's complaint of harassment or discrimination. I had this one instance where one individual wasn't comfortable going by herself to the supervisor about an incident. And in that respect, what was done is the person recruited a close friend of theirs within the company, and they both went and reported the incident. Now, that person the friend was supporting the coworker's complaint. That person is engaging in protected activity and has, the protections that are against any retaliation. We might not have any kind of control over the investigation. So, individuals may be called to provide a statement or to provide information about what they know in the process of an investigation. Being that person also affords protection. Okay. If there's a complaint and whatever statement or information is made in good faith, okay, even if you're mistaken, even if the person's statement or information is mistaken, they're going to have protection from retaliation. Now, if a person is willingly submitting what's called, a false complaint, or providing a knowingly false statement or declaration in the process of an investigation, then there's not going to be protection from retaliation. There might be some disciplinary action that takes place. So what constitutes retaliation then? Adverse employment activity, right? Any action that reasonably likely is going to prevent somebody from engaging in the protected activities we talked about. And those include, again, discharge, demotion, any kind of suspension, any kind of denial of promotion or job benefits. And when there's no legitimate business reasons for doing any of this, it's further harassment. If something does happen, somebody makes a complaint about harassment, and then they get, further harassment, that's going to be retaliation. If there's any threats or intimidation because somebody went ahead and had a complaint, any kind of reprimands where there's no legitimate business, and in some business reason, and in some instances, it can also include a negative evaluation that has no substance, that is without foundation. So, all these kinds of things will be deemed adverse action. So to conclude then, and some food for thought here, the law is going to, the law defines harassment and discrimination and the standards, and those certainly can be complex, right? The reality is that the workplace and companies strive to create and implement policies and practices that are more in line with what's professional, what's respectful, what's courteous treatment, right? And, the way that we ought to be behaving, and interacting with people on a daily basis. So I think that concludes the training. There is a certification form here that we can certainly discuss. I think it's part of the materials that are being provided to you with respect to what to do here. So, Tom? All right, see, what do we have here?
Tom, you were muted.
There we go. Thank you, Carlos. And it's been very, very helpful, informative information. I want to thank you. I want to thank everybody at SmithAmundsen for providing this. I want to remind everybody, it's our mission at BBB to not only promote marketplace trust, but to provide valuable information. So today's webinar will be available soon at bbbwebinars.org. There you'll find a lot of our great webinars from not only today, but from the past. And again, that's bbbwebinars.org. Thank you so much for joining us today. We really appreciate your time tuning in. And this concludes today's webinar. Thank you, Carlos.
Thank you. Have a good day, everybody.